horse down someplace, or he's laying. The weather's held us down this morning due to low ceilings, particularly in the mountainous areas, and then the ceilings in this area has been marginal.
Over a period of approximately 60 days or 2 months, why we were able to raise approximately $17,600 to buy some much-needed equipment to assist Terry to live a fuller and more productive life.
I just met him. I wish I would have known him, because I don't know. I wish someone would explain to me just what is happening, because I don't know what's going on. I come home from the vet, taking my dog up there, and he looks like he's been beat up. They're throwing him in a car.
Back in January, 2 people were killed on the shores of Lake Overholser. Marty Ray Artizone pled guilty to the murders. He committed them while out on parole on a previous robbery conviction. Within the month, an employee at a service station was killed on Northwestern. His throat was slashed. The man accused of the slaying was out on parole.
People in general are tired of what they view as laxness on the part of the criminal justice system.
Lieutenant Mike Heath believes a high percentage of crimes are committed by repeat offenders. That's why he's circulating a petition that, if passed by voters in November, will require all convicted criminals to serve at least 1/2 of their sentences before they become eligible for parole.
Now that it has received publicity, the response is starting to be overwhelming. The calls just this morning is just unbelievable as far as people who want to both circulate and also who want to sign the petition.
The Pardon and Parole Board administrator says he understands the frustration behind the petition drive, but he doesn't think it's the answer.
In philosophy, it's much better to release people through parole supervision so that they can be monitored, so that they can be assisted in locating jobs, so that they can be assisted in locating home, so that they can receive assistance with problems they may have, such as alcohol or drug problems, rather than just being released straight from the penitentiary with no assistance and, in many cases, no place to go.
The parole board says they've been following the guidelines laid down by the state legislature. If voters in November decide to change those guidelines, then they say they'll follow those too. But they don't think it'll make much difference. Mandatory sentences have been tried in other states without any change in the crime rate. Ted Brown, Action 4 at the state capitol.
I get, calls and letters from all over the country. And one of the things that the people seem to be most concerned about is the fact that a federal judge can rule that there be no jury trials and then incarcerate me for an indefinite period of time, then seize my private property, and then state publicly that I'm a thief when I've never been charged with breaking a law and never had access to a jury trial.
A viewer writes in and says, I have an aunt who can no longer take care of her affairs. I've been told that I should have myself appointed as either a guardian or a conservator. What is the difference, and which should I be? Well, as to which would work best in your case, only the specific facts will determine. A guardianship is used when the court considers the person to be incompetent. That is, they are unable to care for themselves or their property. A guardian, once appointed, has control over the individual's person and their estate or their property. A person need not be incompetent to have a conservator appointed, and they can even make that request themselves. A conservator has authority only over the individual's property and not their estate. If your aunt can no longer take care of herself or her property, then a guardianship would appear to be in order. If she can care for herself but needs help managing her property, then a conservatorship might be more appropriate. For Action 4, this is Ray Vaughn with Legal Briefs. An Oklahoma City viewer says, my wife and I have some property that we would like to sell and then give the money we receive to our children. Who would be responsible for the tax on such a gift, us or the children? Well, you would be responsible for the tax on the gift and not your children. However, this year you and your wife can give a total of $20,000 to each of your children without incurring any gift tax liability. So if you had 3 children, for example, you could give up to $60,000 without having to pay tax on the gift. Further, that money comes to your children tax-free and does not have to be reported on their individual income tax returns. For Action 4, this is Ray Vaughn with Legal Briefs.
Oh, crashed again. You know, these games are enough to drive you crazy. But as it turns out, these video games have been driving some businessmen crazy too. Owners of movie theaters, roller rinks, amusement parks, swimming pools have all seen their business reduced because the children who are out from school in the summertime are no longer going out. They're staying home playing these video games. What's this going to lead to? Probably in the next couple of weeks you're going to see some big discounts, 2-for-1 offers, reduced prices on matinees and things like that. It used to be said that home is where the heart is. Unfortunately for some businessmen, home is now where the video game is. For Action 4 News, I'm Will Clark, and that's the bottom line. Three years of graduate school, and I don't know the first thing about painting a house, but at least I'm not alone. In fact, home repair and home improvement on a do-it-yourself basis has become very big business. Firms like Stanley and Black & Decker have been cashing in on this trend. Now, the reason for the trend is not hard to find. The average price of a new home in Oklahoma City last year was $83,000. Couple that with 16% mortgage rates, and it's not hard to find why people are fixing up what they have rather than buying something new. In any event, this trend will probably continue, and that's good, because after you're through at least, it's very satisfying for the individual homeowner, and it's good for the economy. For Action 4 News, I'm Will Clark, and that's the bottom line.
An Oklahoma City viewer says, a few weeks ago my landlord put a for sale sign up in front of my duplex. Now he wants me to give him a key to my side so that he can show prospective buyers through my place while I'm away. The lease doesn't give him that right. Do I have to allow strangers in my home when I'm not there? No, you don't. Oklahoma's landlord-tenant law says that your landlord is to have reasonable access to the premises, and that unless it's an emergency or is impractical, he's to give you at least 24 hours notice prior to showing up and wanting to see the place. Obviously, no notice is required if he's responding to an emergency, nor if the giving of a day's notice would be impractical. Certainly, reasonable access would mean reasonable for both parties, and he could no more show your place late at night while you're trying to sleep than you could deny him access during the day or early evening following sufficient notice. For Action 4, this is Ray Vaughn with Legal Briefs. A viewer writes in and says, my husband and I are divorcing. He was a career military man and presently receives a monthly military retirement check, which he will continue to receive for as long as he lives. I feel like I did my time in the military too, and should be entitled to part of his pension. Am I? No, the United States Supreme Court and Oklahoma courts have both held that a husband's pension or retirement benefits may not be distributed to a spouse as part of a division of property in a divorce decree. The courts, however, may consider the amount to be received by the husband in determining what to award the wife as alimony, if appropriate. Therefore, in a sense, the wife can receive credit for the benefits flowing to her husband from his retirement income. This, however, does not prohibit the husband from agreeing to transfer all or part of such a benefit to a wife or to his children as part of a private property settlement agreement, which the court can approve and later enforce if necessary. For Action 4, this is Ray Vaughn with Legal Briefs. A Shawnee viewer writes and says, can a step-parent adopt a stepchild without the consent of the natural mother? It has been 4 months since we heard from my stepchild's mother. She often disappears for from 3 to 6 months, and we presently don't know where to find her. Under the circumstances you've described, the court would require the consent of the child's natural mother before allowing you to adopt the child. However, if the child's mother fails to contribute to its support in a manner within her means, or as ordered by the court, for a period of 1 year, then the court can find that the natural mother's consent is not necessary and proceed with the adoption based only on the consent of the natural father, your present husband. For Action 4, this is Ray Vaughn with Legal Briefs.
We've kind of crawled through the infancy stage of this program, and we hope now that the thing is really getting moving. We've heard just tremendous feedback from the community and the acceptance of it, and we hope this is just the second of a long list of things that we'll be able to do for children in Oklahoma City.
Donations coming on in pretty well?
We've been in touch with EPA discussing the possibility of getting a change in their attitude relative to a crisis exemption for the use of paraquat this year, but they have refused to change their position until they get more residue data from the chemical company that makes the product. So as of right now, we are bound to stay with the decision that we've just made.
The average patrolman stops as many as 8 to 10 motorists a day, and each time he leaves the safety of his vehicle, he runs the risk of being shot.
Patrolman Sammy Williamson was one of the unlucky ones. On November 5th of 1981, Williamson pulled over a vehicle near Okemah on a routine traffic violation. Instead of writing a ticket, Williamson got involved in a gun battle that left him with a bullet wound to the face. Today, Williamson faces at least 2 more operations before he can report back to work. 53-year-old Trooper Norman Keoghs is in stable condition at Baptist Hospital today. Keoghs was shot 3 times Saturday morning by a motorist he had pulled over for speeding on the Indian Nation Turnpike. Keoghs should be able to return to work in several months. But what possesses anyone to risk their lives on a daily basis for a starting salary of no more than $327 a week? Lieutenant Pat Smith has been in the field for more than 7 years. And although he's pulled over hundreds of cars, he realizes the risks involved.
You have to think about yourself and your personal safety, and you know, it's easy to get laxed out here, and you just have to watch it. You have to worry about traffic coming up behind you, and be pulled over far enough that somebody won't run over you on coming up from behind. And then you always watch their hands. They can't do anything without their hands. You know, they can't pull a gun out of their pocket or anything else, so you just sort of keep an eye on their hands all the time.
Smith will continue to pull over speeders and people with expired auto tags, but he is always aware the next motorist he stops may be his last. Kurt Autry, Action 4.
A viewer writes in and asks, my husband and I are divorcing. I'm to have the custody of our 2 minor children. All of my family lives in Texas, but when I told my husband I was going to move back there, he told me that the court here would not let me and that I would have to keep the kids in Oklahoma. Is this true? No, there's no law that would require you to remain in Oklahoma under such circumstances. If the court grants you custody of the children, then they will be under your control and they will live with you wherever you choose, although that will have some effect on your husband's visitation rights. Further, once they've been in your new home for the period of 6 months, the court there will assume jurisdiction of any further proceedings regarding their custody. For Action 4, this is Ray Vaughn with Legal Briefs. An Oklahoma City viewer says, last summer I was without air conditioning in my apartment about 60% of the time. This summer it's the same old story, and my landlord has done nothing to solve the problem. I decided to withhold a reasonable amount from my rent payments to offset the value of services that I've lost, and now I've been served with an eviction notice if I don't pay in full. What's the law on my situation? Oklahoma's Landlord-Tenant Act says that with regard to heat, running water, hot water, electricity, gas, or other essential services, you must give written notice of the problem to your landlord, and then you have essentially 4 options. You may immediately terminate the rental agreement, you may procure reasonable amounts of these essential services and deduct their expense from the rent, you may recover damages based on the loss in value of your rental unit, or you may find substitute housing while the problem persists and you are excused from paying rent to the landlord during that period. The law does not specifically speak to air conditioning, but it certainly could be argued that such is an essential service in Oklahoma. For Action 4, this is Ray Vaughn with Legal Briefs. A Midwest City viewer says, my husband co-signed a note with our daughter and her husband for the purchase of a new car. They then decided they couldn't make the payments, and the car was repossessed by the credit company. What will happen now? The holder of the note will sell the car for as close to its fair market value as possible, and if they receive enough from it to pay off the note and cover their expenses, then you probably won't hear from them again. However, if the car doesn't bring enough to pay it off, and its value is more than $1,000, then your daughter, son-in-law, and husband will have a deficiency judgment taken against them for the amount of the balance. Once the judgment has been entered, their wages could be garnished or other non-exempt property taken and sold to satisfy the debt. For Action 4, this is Ray Vaughn with Legal Briefs.
The Boley State School is home for about 100 delinquent boys. The 12 to 18-year-olds live inside dormitories on the school grounds. Friday night, a couple of students began fighting. 8 others joined the melee. Boley officials broke up the fight, but they faced a problem. 2 days before, a state judge had ordered the school to shut down its 4 solitary confinement cells. The state attorney general complained that confining students in solitary cells violated a recently passed state law. He also maintained that the 6 by 8 foot cells were too small to meet federal standards. With no place else to turn, school officials asked state troopers to take the youngsters away. The 10 Boley students spent the night in the Pottawatomie County Jail. Saturday, the welfare department asked the judge to allow Boley officials to use the solitary confinement cells.
These were detention facilities and had locks on them, and we used them to for incarceration, I guess you'd call it, of residents when they got beyond control and needed a cooling off period, and we never keep them in there for over 3 hours at a time. And under the temporary restraining order that was issued by Judge Miracle, we could not use those, and so we filed an application on Saturday with the judge and asked him to rescind that order until we could be heard on it this coming Thursday.
2 students have since been returned to Boley. 4 others have been sent to another high-security juvenile institution. The remaining 4 will probably be shipped to that same institution shortly.
District Judge Jess Miracle has set a hearing for Thursday afternoon on the confinement question. After hearing both sides, Judge Miracle is expected to decide once and for all if the Boley State School can use its solitary confinement cells in the future. Scott Wallace, Action 4 at the Boley State School.
A Dibble, Oklahoma viewer says, my car was totaled on June the 12th, and on June 20th, the Oklahoma City Police Department called to say they had found it and I could pick it up the next day. They asked me to bring my title to prove ownership, and when I did, the serial numbers didn't match. It was then that I discovered that a previous owner, not the fellow we had bought the car from, had accidentally mixed up the titles on 2 similar cars. This cost me an extra day in getting my car and over $100. Can I take the guy to small claims court and get my money back? Well, it's highly unlikely. The previous owner had no contract with you and owes you no duty. You might recover from your seller who passed the defective title on to you, but then you accepted it without objection and apparently without inspection. Unfortunately, the best case for recovery is against the one who it will be the hardest to find, the car thief. For Action 4, this is a horse, Ray Vaughn, with Legal Briefs. A Dibble, Oklahoma viewer says, my car was stolen on June the 12th, and on June 20th, the Oklahoma City Police Department called to say they had found it and that it could pick it up the next day. They asked me to bring my title to prove ownership, but when I did, the serial numbers didn't match. It was then that I discovered that a previous owner, not the fellow we had bought the car from, had accidentally mixed up the titles on two similar cars. This cost me an extra day in getting my car back and over $100. Can I take him to small claims court and get it back? Well, it's highly unlikely. The previous owner had no contract with you and owes you no duty. You might recover from your seller who passed the defective title on to you, but then you accepted it without objection and apparently without inspection. Unfortunately, the best case for recovery will be against the one who it will be the hardest to find, the car thief. For Action 4, this is Ray Vaughn with Legal Briefs. A viewer writes in and says, the monthly payments on my home include an amount that goes into what is called an escrow account. What is this account for, and would I be entitled to a refund if I sold my house? This money, sometimes referred to as escrow money, is collected by your mortgage company to assure the payment of your real estate taxes and insurance. This in turn protects the mortgage company's interest in your home. If you sell your house and the loan is paid off, then you are generally entitled to a refund of the unused portion of this money. But if your buyer takes over your loan, it usually stays with the company, and that amount is added to what you receive in the sale. For Action 4, this is Ray Vaughn with Legal Briefs. An Oklahoma City viewer says, my son was involved in a hit-and-run accident. Even though he was not seriously hurt, the car was totaled. He got the license number of the car that hit him, but so far the police have come up with nothing. What can we do to get the bills and the car damage taken care of? Well, your son can collect on his insurance policy for the damage done to his car and can also make a claim under his uninsured motorist coverage for his injuries. The law presumes that a hit-and-run driver is uninsured, and therefore your son's insurance company must pay for his medical bills and compensate him for his pain and suffering and lost wages. For Action 4, this is Ray Vaughn with Legal Briefs. A viewer says, in my opinion, my parents are making some bad decisions. They are quite elderly, and I would like to know what my chances are of becoming their legal guardian. In order to have a guardian appointed to take care of the person or property of another person, you must show to the district court that your parents are of unsound mind, which is generally evidenced by their inability to care for their property or themselves. After showing such evidence, the court has the power to appoint you as the guardian over your parents, which will in turn give you power to control and manage, under the court's supervision and approval, their person and their property. For Action 4, this is Ray Vaughn with Legal Briefs. A viewer says, my 7-year-old son recently broke 25 car windows. As his parent, am I responsible for the broken windows? And if so, what can happen to me if I refuse to pay? Under Oklahoma law, neither parent nor child is responsible as such for the acts of the other. However, a parent can be liable for permitting a child to commit acts that they should have known to be dangerous to the safety of others. In this case, it could depend on whether or not you knew or could have known that your child had a tendency to break windows. In other words, has it happened before? If you're responsible and refuse to compensate the owners for the damage caused by your son, you may have a civil lawsuit brought against you. For Action 4, this is Ray Vaughn with Legal Briefs.